Case number 18, People versus Marcus Hogan. Ms. Gorman, good morning.
If it please the court, Your Honor, a 1 minute rebuttal. Shirley Gorman from Marcus Hogan. With respect to the presumption, this is a drug factory presumption by its very terms, not a drug store presumption. The legislature knows full well how to say with intent to sell, yet they did not do that. And the reason is you catch the wrong people if you're looking at just drugs sitting on a table.
So preparation for sale, that doesn't include, I mean, where there's a razor blade, maybe, breaking things up and putting it into plastic baggies?
No, that would be preparation for
Okay,
sale.
so why wasn't there evidence of that here?
The evidence in the People's case was that the cocaine was in the carpeting and that no one saw it, that cocaine, and the razor blade was on the floor and no one saw it initially, so that cocaine was not in open view. If you look at the cocaine that was sitting...
So if something's sitting on a carpet, but it blends in, that's not open view?
I don't believe it is. If you go through the scene and you take photographs and people walk through and don't notice it, and then somebody is searching and finds it, that's not open view. The cocaine sitting on the microwave table is open view. 6 bags sitting there already packaged, individual packages that are unused but weren't the same kind as the ones that were packaged. The defense witness indicated she had the cocaine that was on the floor in her hands as well, and that it went flying.
Is your position that this was for personal use?
The defense attorney made multiple arguments and made arguments that the cocaine sitting on the microwave table was for personal use, only 6 bags. Obviously, the courts didn't agree with that, or they would not have found that there was an intent to sell here, and one of the elements was intent to sell. So
I guess I'm just trying to tease out if part of the argument is that when you have the kind of evidence that lends itself equally to an inference that it's for personal use as well as possibly that it's for intent to sell, whether or not the presumption applies in those types of cases.
Well, the presumption, lower courts have held the presumption doesn't apply for a misdemeanor weight because, or misdemeanor circumstances, because it does take this circumstances evincing mix, compound, prepare for sale.
I thought it was an intent to unlawfully prepare a sale. Pretty much.
I'm sorry.
I thought the fourth prong of the drug presumption, the drug factory presumption, was an intent to unlawfully prepare a sale.
Prepare for sale.
Right.
And that would be things like putting it in bags or doing something like taking crack and cooking it.
But you don't have to be in the process of it. Usually it's the nature. There's razor blades, there's drugs, and the nature of the bags themselves sometimes are pointed to.
The bags would show an intent to sell. If you have a lot of unused bags, would probably indicate an intent to sell. But again, I'm arguing intent to sell is not enough. If you have a confidential informant who goes in and makes a buy and sees a bunch of cocaine sitting on the table and there are 5 other people in there, he leaves and tells the task force there are drugs in there, so execute your warrant. You walk in there and there are 5 other people in there in addition to the guy who sold. It's just sitting on the table already bagged. You're catching other purchasers. There's nothing there that would indicate that all of those 5 people sitting around the table were there because they were all involved in drug selling. If you're measuring, if you're packaging, if you're doing something with those drugs, you won't be there unless you're part of that drug business.
Well, this was added to the automobile presumption, and it struck me that sure there's an inference, but it's rebuttable. And if somebody, said, hey, I was just swinging by, I was coming in to watch the football game, you can raise that. But doesn't the inference still stand? And we've got a trier of fact here that found that it did.
that relied on the inference.
Right.
I don't think the presumption should be used to even charge those 5 people.
Well, but didn't he have a cell phone bill addressed to the defendant at the apartment, and
But
there's
the-
some evidence of contact there more than just...
But the judge specifically found no constructive possession under a non-presumption theory because he hadn't lived there. It was an old cell phone bill.
One of the things that struck me about the case was that it was a 9-year sentence, and the co-defendant got probation, and that it took 8 years to perfect the case to get to the intermediate level of the appellate division. Just, I don't want to take you off your argument, just briefly address that, would you?
The public defender's office is assigned first, and then when they reach a case eventually and read it and find a conflict, it then gets assigned to the conflict defender, who does the very same thing, and then it gets handed to assigned counsel like me. So I'm picking up cases that are very old to start with.
When did you get it?
I'm not sure. Typically, this would have been perfected within 120 days or maybe one extension. I don't think I've ever gone more than
No, I don't
two
think you have
extensions.
either.
So that's the delay built in the system, but it is unfortunate.
It really
Right,
is kind of
it
a
is.
startling length of time. to
Right,
perfect
no,
an
it's a
intermediate
2005 incident. If I may address the issue of grand jury and right to counsel, if there is any case where an attorney is ineffective for not allowing his client, providing an opportunity for his client to testify, it is this one.
Why isn't it quintessentially a strategic decision rather than a
Because
fundamental one?
the defendant knows best what happened, especially at that state. The
Yeah,
defendant,
but there are so many pitfalls, even if the defendant knows. There's so many pitfalls to testifying in front of a grand jury.
clearly,
And it's also, it's not a constitutional right.
no, it's not.
So that distinguishes it from some other rights that we've held to be exclusively
Fundamental.
the
And
defendant.
an attorney would be expected, obviously, to give advice, but even if it is a strategic decision, at some point, I don't believe the court's decisions in Simmons and Wiggins were, there is never a situation where you can have ineffective assistance. Here, not only did you not talk to your client about it, you didn't make the 5-day motion, which would have remedied the problem,
If
because
you don't see a problem, you're not going to make that motion, and I think that goes to what Judge Stein just asked. If counsel believes this is a strategic decision that counsel should make, because counsel sees the pitfalls and may or may not be able to explain to his lay, client what those pitfalls are, then of course, it's not compounding the problem if you don't see the problem.
But he made the motion eventually. He didn't say to the judge, sorry, there's no merit to it, or sorry, I didn't make it because I don't think it's
2 months
appropriate.
later, was it the same attorney?
59 days after arraignment. And
Was it the same attorney?
yes, at that point, it was the same attorney.
The way I read Wiggins in those cases was that it wasn't a per se violation.
Right.
Right. So if there are other circumstances that show that there were no tactical or logical reason to do that, in this case, I don't see where that would be, where there couldn't be other tactical reasons for the attorney not wanting him to go in and testify in front of the grand jury.
But shouldn't he consult with the client?
But can he
to
really be
come-
ineffective if this court has never directly ruled on this, and the cases below certainly find that it is strategic, and Wiggins seems to suggest that you wouldn't be ineffective even for making an error about this? Can he really be ineffective with that kind of case law and the jurisprudence in that position, making that call, that I'm just going to make this decision based on what I think is best in this case for my client?
Well, and that's clearly what he did. But he did that without talking to the client. And had he talked to the client
I
might-
understand your point about that. My question is, can you really say he's ineffective given the jurisprudence at the time that never suggested that he had to speak?
I'm not
I
sure.
mean, your
so-
position, I don't think, is that the law was crystal clear, right? That's not your position.
No. And there are cases that say the reasonable notice is to give a defendant the opportunity to consult with his attorney and decide whether to testify. And that consultation obviously means it's the
Do we
lawyer.
really know, based on what he said, that he didn't have some sense of what the client would say? He may have said, I understand your point. They said, I didn't talk to him about this once I knew about this. But can we really say on this record that he didn't have some sense of what the client would say and made a choice based on that?
He may have had some sense, but
Does it make him ineffective if he had some sense? If they had perhaps discussed this, something on a prior occasion about what the defendant's position was, what the facts were?
if he didn't say, what would you say? And here's something that could be totally new. Because clients put in that position, they'll tell you what happened, and then when you sit down and, okay, you want to testify in grand jury, what would you say? You may hear.
Sorry, Counsel, at the time that the grand jury was called, or he was called or allowed to go before the grand jury, wasn't he also being tried along with his co-defendant, who the severance hadn't occurred by then, right?
No, and
So if his co-defendant had gone into the grand jury and given one version of what went on that day, wouldn't it have been important for the defendant not to go in there and commit to any particular story or have some impeachment ability? I mean, it seems very strategic to me.
his co-defendant was assuming responsibility for the drugs to the point where the reason this was adjourned in city court is a defense attorney wanted to subpoena the co-defendant for this preliminary hearing. Because she was saying, they're my drugs. She sent a letter to the DA's office saying they're my drugs, he's not responsible for it.
Had that happened at the time the grand jury was convened?
In terms of the date the DA got the letter, I'm not sure. But the defense attorney clearly knew she was assuming responsibility because he's asking to subpoena her to the prelim.
But your argument is, as I understand it, that it's not a strategic choice. He doesn't get to make the strategic choice. It's the defendant's choice, period, in consultation with counsel. But it's and even if it was a strategic choice, even if he could have done that, there is no strategy here because he had no conversation about this particular grand jury testimony.
Yes.
Just to clarify where.
Yes, and no strategy in not making that 5-day motion because it would have been dismissed and represented, and what do you lose by that, even if you, by then, have convinced your client not to testify?
So regardless of how long, so here the notice was from Friday to Tuesday, I believe, right? And I understand there was a holiday weekend in between, it was late Friday. The grand jury was in the afternoon on that Tuesday. So, there was some time there. Again, I mean, so if it was one more day, if it was a week, at what point does it become ineffective not to make the motion? Because, gee, if you win, there's nothing to lose here. But then wouldn't you always make the motion, no matter how much time you got?
No, because it has to be lack of reasonable notice, and the cases are 2 or 3 days is sufficient. Here, with the 3-day weekend, faxing this on a Friday afternoon at 4 o'clock.
Well, if it was Friday at 4 o'clock and they were meeting at 9 o'clock on Tuesday, that would be, I think, a closer case. But.
Right. But
Well, it's not Friday at 10 p.m. 4 o'clock is still a business hour.
Right, but the attorney had left for vacation
Well, I
on the
understand that,
3
but
days.
it's still a business hour. The attorney has no backup in the office.
Right. And
Might get faxes through email like we do sometimes.
Well,
Right.
did he?
Maybe
We're never not
now.
on duty.
not
Did he in
2005.
I was going to say, I don't know about 2005.
Thank you.
Thank you, Ms. Gorman. Mr. Shoemaker, good morning.
Morning. May it please the Court, Robert Shoemaker for the people. This was a prototypical drug factory presumption case.
Let's go to if you could, to the second point, because it disturbed me. Judge Fahey enlightened me without knowing it, because I thought faxing, really? But I didn't notice that it was 8 or 9 years ago. But boy, did that seem like a cheap shot to me for a district attorney's office to fax a defense lawyer rather than serve them or call them a notice for a grand jury on the day after a long weekend. It just didn't seem right to me. Is there an explanation for that other than gamesmanship?
Well, I wasn't in the office at the time. I don't know this particular
Well,
assistant
unfortunately,
district
you're
attorney.
charged with representing the entire office.
I don't think it was gamesmanship. I think it was after the court appearance, when the preliminary hearing was supposed to happen, the assistant district attorney realized she wanted to present it to the grand jury on Tuesday, faxed notice. It was during the business day still on a Friday, and given that it was the afternoon on a Tuesday, the defense attorney had that amount of time.
How about calling? And
I think there's testimony, or there was talk at the motion argument stage that there was a call. I don't know when the call happened, but that's when the defense attorney told the prosecutor that he
Well,
wasn't.
it's true. There was one, at least conversation that they were not going to appear.
Right. So I don't know how soon before the presentation or the completion
I got
of
the
the
impression that that was afterwards. I mean, that not after the presentation, but maybe on that Tuesday or whatever.
I think
I think it was after the holiday.
Yeah, I think I got that impression too, but there was
Doesn't that
still.
seem odd? I mean, to me, just in terms of professionalism, why would you, geez, grand juries are kind of important.
And we don't know, actually, we don't know from this record whether the assistant district attorney did try to call on Friday. We just don't know. We don't know if fax was the only thing that happened, but the fax is what is in the record.
No, but certainly didn't archive it to
The phone
preserve
call.
some kind of record about the efforts made by the ADA.
Correct.
No matter what, I just don't know why you would do this. Why on a Friday you tell somebody that the next business day, tomorrow morning we're presenting your case to the grand jury. It's effectively what it was, because Saturday, Sunday, Monday were all holidays. And
Well, yeah, and in cases like that where it actually is the next business day, the appellate divisions have reversed for lack of notice. In this particular case, I know it's a holiday, but there were there's the Friday, there was an hour left in the business day, there was all day, basically all day Tuesday for the attorney to have considered.
I took you off your game. You wanted to talk about the other issue.
Oh, well, it's a prototypical drug factory presumption case here. We have the crack cocaine in open view in the kitchen, living room area. There were baggies on the countertop with the new and unused cocaine. There was loose cocaine and razor blades on the floor in front of that countertop.
Let me ask you the question I was asking before. So those things can also, I think the baggies is the strongest evidence to get that inference of the drug factory. But if the evidence really is the kind of evidence that evinces either the intent to sell or personal use, it really could be either one. There's nothing that tips the scale. Why should the presumption apply?
If it could go either way? Basically.
Correct.
The presumption should apply because the presumption was created as a fix for this error where police would come into a house, or not an error, but a situation where police would come into a house and there would be no proof.
Yes, but it's not set up also to catch people who are basically drug users in their home or wherever they're drug users, right?
I think that's why you need the evidence or the
Right.
evidence
So
that evinces.
if you don't have the presumption, let me put it this way, if you don't have the presumption, it doesn't foreclose the people from nevertheless trying to establish an intent to sell, correct?
Correct.
It just puts you right back where you are for every other case, other than where you have this presumption.
Without the presumption, it puts you back. Yes, it does.
But with the presumption, the defendant now has a burden that they don't otherwise have, right? Because they've got to rebut the presumption. Because they're basically assumed guilty, as opposed to assumed innocent.
Right, and
Is that really the effectiveness of the effect, of the presumption?
Yeah, and as for the wisdom of whether the presumption should have come into
Absolutely. So
effect.
that's why I ask, can we really say that then when the evidence evinces that really we're at 50-50 with whether or not it's an intent to sell or for personal use, that's not an appropriate application of the presumption?
I'm not sure I would go that far because just
You're
because
going
it's
to
not,
shift that burden. Should we do it in those kinds of cases?
I think maybe we should, given what the statute says. The statute says when it's there, when there's evidence that evinces packaging or mixing or compounding, then the presumption applies. I don't think the statute says, if it's equivocal, it doesn't apply. The statute says...
The legislature could have said, if it only establishes.
Correct. They could have said that. but
One
it's
word
not.
could have made that difference.
Right.
Counsel, could you address what your adversary said about the lack of plain view of the razor blade and the cocaine that was on the floor?
Yeah, and I disagree about that. I think it was in open view. There was nothing covering it. There was no furniture covering it. Basically what I think the theory of the people and basically what the theory of this presumption in general is that defendant was there where the drugs were, panicked as soon as the first battering ram hit, as soon as he heard the first battering ram hit, and then the drugs fell on the ground. The police missed it in their first sweep, I think, because it was on a carpet. They weren't necessarily looking. But they eventually did find it. There was nothing covering it. It was exactly where it would have been had someone panicked. And this is what the co-defendant testified that she did. But
Is it a small amount of drugs suggesting it's really for personal use, or no?
No. There was testimony that, there could be that maybe that's all there's left, and they've sold all the rest of it. And B, there's 6 packaged baggies on the counter. There's more loose on the ground, I think, that they were the theory was that they were using that loose cocaine with the razor blade. They were using that loose cocaine to put into the packages. And, of course, here there were 50 unused baggies.
What if there had been no razor blade and just pieces of cocaine and bags?
I think it would have been a closer case, but I still think the presumption would have applied, especially with all the baggies. If you have the packaged cocaine, the loose cocaine, and all the baggies you're putting it in, maybe you just don't have a razor blade, but you can still be packaging the cocaine. So the drug factory presumption was rightfully applied in this case. The defendant was actually seen running from the area where the drugs were. As for the grand jury issue, I'd like to spend just a minute on that if I could. Defense counsel here did make a quintessentially strategic decision not to have his client testify in the grand jury. The decision was counsel's to make, and it was founded on the well-known disadvantages of testifying in the grand jury. He actually
What's the scoop on the letter that, that Hope Fisher sent saying that she was responsible for all of this?
I don't know why she did that. I know he had a record and she didn't.
What was the date?
I'm not sure.
Because I'd never put a defendant in the grand jury, but unless I had something like that. I mean, if I got somebody who's going to take the weight, and I can go in the grand jury and say, Hope did it, and by the way, she already told you that, and I don't know why you've got me in here.
And even apart from the date that was on the letter, defense counsel did know something about, even if he didn't have the physical letter, he knew that she was going to be taking the fall for this. That's why he adjourned the preliminary hearing to call her.
And could counsel, regardless of what a client might actually articulate, believe that the client's manner of presentation is enough to be grounds not to let them testify? That is to say, you're just not credible. No matter how you say this, no one's going to believe you, regardless of the content. Could that be a basis for a lawyer to make a strategic choice, say, you're not going in there?
Yeah, it could be. And that's what many of the appellate divisions have held. This Court, I don't think, has held explicitly why it's a strategic decision to have a client not testify in grand jury. But the probability of a dismissal is remote. And then on the other hand, you have the presentation of the client.
Would he have won a motion to dismiss? Would he have won a motion to dismiss had he brought one for failure to properly notify them?
No, I don't think he would have.
No.
Given the timeliness, you mean?
Yeah.
No. I think because it was during the business day on a Friday, you had all these days intervening. I don't think it was enough.
How do you make a strategic choice without talking to the client, which is her other fallback position? First, it says not a strategic choice, but even if it is, a strategic choice means you're thinking about what this presentation might be like and making a choice about it.
And he had spoken to the client, not about grand jury, but he'd spoken to him. That's why he knew what the co-defendant's position was. He was involved in this case. It wasn't like he just stepped in and said, oh, no, we're not.
So that might be a different case. That if he literally had not had an opportunity to really have had some type of perhaps robust conversation with the client, that might be a case where you'd say, no, the likelihood of a strategic choice is 0.
Potentially. And that's
not this case.
Right, it's not. I would go to Wiggins where this Court said that not testifying in the grand jury does not per se amount to a denial of effective assistance.
Thank you, Mr. Shoemaker.
Thank you.
Ms. Gorman, you have rebuttal.
With respect to the letter, the grand jury presentment was May 31st, and I remember something about the DA getting that letter, I think, on June 3rd. So she would not have had it before the grand jury presentment. With respect to the cocaine in the carpet, the officer who found it said he did not remember whether anything was covering it. He said he didn't have to move anything and he didn't think there was furniture covering it, but he didn't remember whether there was anything covering it. And it is their burden beyond a reasonable doubt to prove it's an open view for that presumption to apply. And the greatest danger with this presumption is that it traps everybody in knowing possession. So even if there is no intent to sell, there's knowing possession of felony weight cocaine. Thank you.
Thank you, Ms. Gorman.